Hello everyone, welcome back to ACCA Law Revision Series. In today's lecture, we are going to cover ethics and professionalism along with international law. Now, this is one of those topics which students usually label as theory. Because of that, they either ignore it or try to cram it. And both of these approaches are wrong. This chapter is actually very logical. The moment business starts happening between parties from different countries, legal complications are bound to arise. And that is where international law becomes important. So, in this lecture, we will understand the types of international law, its major sources, the role of important international organizations, and how legal disputes are resolved through courts. We will keep the discussion simple, conceptual, and completely exam oriented. So, let's get started. As discussed earlier, when two parties from different countries engage together and get into any contract for doing trade, there are high possibilities that dispute might happen because there are different legal structure in different countries. To make sure that there is no such dispute happening, or to make sure that there is an orderly resolution to such disputes, international law comes into picture, and both the parties are supposed to follow that international law. This we have discussed already in our previous lectures. Now let's focus on what is international law. How does international law works? There are two types of international law. There are two types of international law. The first one is private international law, and the second one is public international law. Now, what is private international law? It is domestic rules governing in your country that handles cross border legal issues. Meaning, let's say if you are residing in your particular country, let's say UK or India, there are some rules that already exist in your country that describes that if you enter into a cross border transaction or cross border trade, how you are supposed to deal with it. If any legal issues arise, what you are supposed to do. These determine when international law overrides domestic law. So let's say in domestic law, if something is written, let's say, for example, hypothetically, as usual, if it is written in domestic law that in a contract you're not supposed to uh, give an advance payment, like you're not supposed to uh, hold payment on credit for more than 90 days, that is written in domestic law. But in international law, it might be written, or in the other party's country it might be more than 90 days, it might be 180 days or so. In such case, a dispute may arise that in my country it's only 90 days, in your country it's 180 days, but I want you to pay me in 90 days. In such cases, law exists that may override the domestic law. So such law may exist in my country itself, saying that even though domestic law says 90 days, but when you are into an international transaction, you can follow up to 220 days or so. This is very hypothetical. 220 days is like too much, but hypothetically, that is what private international law does. It is an international law, but it is applicable to your country when you are entering into such international deals. It deals with conflicts between difference of legal systems in civil or commercial matters. Then what do you mean by public international law? This is applicable altogether. Like private is applicable only to your country, that your country law is overridden by your country international law. However, public international law is something that is agreements between two nations, such as treaties and conventions. That means in case of private law, your country has made that particular law, but in case of international law, two country people sit together and come to a common ground that, let's say, for example, India and China, people are sitting together and they have discussed that whenever any contract happens between your country's individuals and my country's individual, they are supposed to follow these rules and regulations or these law. That is what is called as public international law. These are set rules for cooperation in areas like trade, travel, environment, human rights, and military matters. Binding only when countries accept or ratify the agreements. What do you mean by ratify the agreement? We will soon discuss that in our upcoming chapter, that is Contract Act. However, here in this case, both the countries are supposed to accept this international law, which was not the case in private international law. Now, what are the sources of this international law, ma'am? From where these people are making these international law, they might be referring to something, right? They might be referring to some rules and regulation to make this law. International law draws authority for several key sources, including international treaties and conventions and international customs. That means that, let's say, if my country is making any private international law, my country is looking at international treaties, that how are these treaties working, which are formal agreements between nations, and then based on those treaties, I might decide to make a particular law also, so that we are on the same page. There is no confusion. See, as of now that we are studying law, it is very interesting to know that if this happens, if that happens. But if you see at a student point of view, these all makes sense to you. But if you see a trader point of view, many a time some traders, they are not that, they don't have that level of knowledge, that they might look into private international law and then check whether if there is any treaty, if there is any public international law, and see if anything is contradicting each other or not. That is a very tedious work. They are here to make business, to make sure that business is happening, and not to make sure that I'll make a fraud, I'll make something wrong out of the contract. This is we as students who are thinking that what if this happened, what if that happened. It's all wild scenarios in our head, right? So in case of international treaties, how come they are the source? Because to make sure that everything is on the same level, everything is on the same page, such treaties are referred as sources. International customs, such as practices that have been consistently followed by all the countries, by states, out of sense of legal duty, out of sense of any legal duty, you can refer to it as source. Let's say any previous case law or something like that. Model law. What is model law? Model laws are draft laws created to help countries develop or reform their domestic legislation. They are not binding, nor do they have any legal force unless country voluntarily adopts them. Their purpose is to reduce differences between national laws. What are model laws? It is more like that it exists. It is not compulsory that you follow, but if you voluntarily want to adopt it, you can. These are common laws that countries might suggest as a suggestion, put in there, and you know to make sure that all the countries are following something which is on the same lines, trying to do that, but it is not mandatory. Now, international organizations, this is important. This is something that you need to remember a little. I'm not saying that you need to memorize things, but here there is nothing much that you might need an explanation. Wherever needed, I will explain. But these are organizations, and these organizations make international law. Is the basic explanation that why are we studying these international organizations. The answer to it is these organizations exist and they make international law, or they regulate international law, even for that matter. The first one is UN. United Nations. What is the purpose of United Nation? It is a global body and it maintains global peace, friendly relationship and promotes human right. What is the structure of UN and key bodies or legal departments to be precise? It has two departments. The first one is Unicentral and the second one is ICJ. Unicentral is basically UN Commission on International Trade Law. It is a UN body for international trade. It has 61 member countries. Basically, 61 countries are associated as members with Unicentral and six working groups. And the second one is ICJ, International Court of Justice. Now, important points to remember: almost every country is a member with UN, major felicitator of international business through courts and agencies. UN is a major, unicentral to be very precise, is a major body that makes international trade laws. It creates global trade laws. The second one is ICC, that is International Chamber of Commerce. It is created by global business leaders. So here no country is involved. Global business leaders are involved that aims to serve world's business community. Who all are into ICC? The first one is World Council, the chief authority here, and executive board have 15 to 30 members. Each member is there for every 3 year, and every year one third member retires yearly. It has chairman and vice chairman as World Council selects. So basically, chief authority is World Council and its chairman and vice chairman is selected by World Council. It has national committees and it represents ICC with each country, and it implements policies and handles arbitration. What do you mean by arbitration? That we will be discussing in our upcoming lectures. So that is what ICC does. It is basically where global business leaders come together and they try to maintain things with their business knowledge, I would say. They advise UN and they help ease international business operation. What do? Is they advise and they help to ease operation. The next one is WTO. We all would have heard about it somewhere or the other. World Trade Organization. It provides the rule structure and dispute system for international trade. What are the rules, etc., that are supposed to be applicable? In what structure it should be followed? And in case if any dispute happens, what are you supposed to do next? Is what WTO helps with. It is an appellant body. There are three member here that appeal. So basically, whenever you appeal, there are three members from different countries in this appellant body. They are formed by general agreement on tariffs and trade. These have 149 members covering 97% of the global trade, and they aim to improve global trade ecosystem. So they have 149 members, something that you need to remember, and 97% of global trade is what they cover. The next one is Organization for Economic Cooperation and Development, OECD. It is a forum. It is basically, so see, UN is again a body that gives you rules and regulation. ICC is a group of business people, they advise. WTO is again that gives you rules and regulation. OECD is a forum where people can come together and they discuss uh, what are the issues they are facing. This forum is used for discussion, developing, and refining economic and social policies. What are the issues that these people are facing? What can be the changes that can happen in the policies? How basically a forum, a place where business people can help out each other and also, you know, uh, give advice, etc., but majorly a discussion forum. It has 30 member countries and work with 70 plus countries globally. So member countries are 30 but works with more than 70 plus countries. They create legally binding agreements. Basically, they help you in short term, they help you to create agreements or discuss with you to how to manage a scenario, so on and so forth. The next one is International Institute for Unification of Private Law, UNIDROIT. Okay, a little big name, but something that you need to probably remember. My advice to you is don't mug things up. I'm not asking for you to mug it up, but in such scenarios where you need to actually remember the number of members, etc., try to create shortcuts or short forms that let's say, if we talk about UN, so you can probably say that in UN everything is here related to 661 members, 6 working groups. In ICC everything here relates to 3 years every member retire, one third retire, so on and so forth. These are just short ways or probably some very kiddish ways to remember, but works in long term, for sure works in long term. All right. So next one is this. It harmonize and unify the private law across countries. Whatever countries uh, are making private law at their end, what they do is they try to make it uniform. Okay, try to make it uniform with other countries. They have three-tier structure. The first one is General Assembly, where main decisions are made. The second one is governing council. It is a supervisory body. It supervise things. And the second one is the last one is secretariat. It is daily operations. Basically, the first one is who make decisions. The second one is they are supervising secretariat also and general assembly also. And secretariat is day to day operation is what they do. They again have 61 member countries. Okay, so here also in UN also 61 member countries, and in UNIDROIT it has 61 member countries. The next one is ICJ. We just discussed that it is a part of UN. What they do is they resolve disputes between nation and not individual. So going forward when we do contract, we will discuss about how individuals resolve conflict, or even up till now whatever examples we have taken, we were discussing that if I am from XYZ country and some other person is from XYZ country, and if anything is going up and down or we are not coming down to a common agreement, then in case what will happen. But in case of ICJ, we are here talking about dispute between two nations and not individuals. So whenever two nations have any particular dispute, it is not important that it has to be any political or disputes that we are looking at these days, that war is going on and so on and so forth. Not those. It, of course, countries trade with each other, so it majorly looks at trading disputes. Like let's say if US and UK are trading with each other, it is obvious that they might have a contract and some trade rules and regulations and terms and conditions. If any of the country breaches those terms and conditions, then when where they are supposed to go, they are supposed to go at International Court of Justice. It is a subsidiary of UN. It has 15 judges and no two judges are of same nationality. It is main judicial arm of UN. Something very important that you should remember. The last second last, or we have already discussed unicentral. The last one is International Court of Arbitration. What do you mean by arbitration? We will be covering that in our next lecture, in fact. Now, there is this International Court of Arbitration that sees overall arbitration when ICC committees are referred, or whenever dispute happens. It is operated by ICC. It is operated by ICC, and it handles international commercial arbitration process. This you can wait for some time. We will discuss what is arbitration, and I'll again repeat this. But if to give you a bigger picture or an overall picture, what is ICA? There is a process called as arbitration, and ICA, International Court of Arbitration, is where this process happened, and who looks over this particular process or court. It is operated by ICC. Now, operation of courts. It is where court is something where legal disputes are resolved, where each party presents their case before judge. Court is something that is very common. I'm assuming that you might know it is basically where any dispute if has happened, people go to court. It's a very common line that if any wrong thing happens, they are like, I'll see you in court. So that is what court is basically a place where judges there and two people resolve their disputes. Parties are typically represented by solicitors or barristers, meaning when you as an individual go to court, you cannot represent yourself. You need a solicitor to represent you. Why, ma'am? Because you don't know how to speak in front of judge. If I give you a very small example, and if you watch Bollywood movies, and if you would have watched that movie called, I think it's Rustam Ji. I don't remember I 99% believe it's that movie. In that movie, um, people are actually thrown into jail because they don't know or they misbehave with the judge. If you remember the scene that Bai tells that if it would have been your wife, what would have you done? You would have killed him only, and she is sent to prison, right? So there are a few ways that you're supposed to speak in front of judge. There are some court room rules and regulations. We have already covered this in our last few lectures where we discussed that there are courtroom rules and regulations that you're supposed to follow. Okay, and if you don't follow those, you will end up being into more trouble. So it's better that you are represented by a solicitor or a barrister. If a party disagrees when the decision, they can appeal to higher court. We have already discussed UK court structure, how there is high court, court of appeal, Supreme Court, so on and so forth. So if any verdict has been passed, and if both the parties or any one party, they are not on the same page or they don't agree with the judgment passed, they can go up to the higher court. The main advantage of going into courts is courts provide clear, enforceable, and legal remedies. So they look into legal aspects and they give you a legal remedy. But the major disadvantage of going into court is court proceedings are often expensive, slow, and drag longer than expected. In short term, again, I'm a Bollywood fan, so I'll give you Bollywood references. Tariq pe Tariq. You keep on getting new date on each and every major of the proceedings. So, in that case, it can be a major disadvantage because every new date can cost you more. Okay. And every single time you are into judgment and a final verdict or final judgment has not come, it will go on to some other date. You have to pay again then to the solicitor, and it is very slow process. So to make sure that these disadvantages does not hamper, there is an alternative brought in which is called as arbitration, that we will be covering in our next lecture, what is arbitration, etc. But I hope you understand how court operates. What are the advantages of court? There is definitely advantage that the judge is more knowledgeable and more legal way is followed, but disadvantages is surely there. It is very expensive and very slow. It keeps on getting dragged. So I hope this much is clear. Major important part of today's lecture, if I tell you, is this: international organizations, do remember what they do, how do they work, and how many number of members they have. So that's all for this lecture. Today we completed a very important conceptual area, international law under ethics and professional. The key to this chapter is not blind memorization but conceptual clarity, especially the distinction between different types of international law and the role of various international bodies. Revise the charts once again after the class because that will help you retain the structure much better for the exam. And once this structure is clear in your mind, answering questions from this chapter will become much more easier. Thank you for watching, and I'll see you in the next lecture.